What does the Constitution say about free speech on campus? The First Amendment to the U.S. Constitution declares that Congress shall, quote, make no law abridging the freedom of speech, end quote. Courts have interpreted this to mean that no government agent, not Congress, not a state, not a city, and not even a public university administrator may abridge the right to speak freely. At public colleges, then, this means that administrators cannot prohibit or punish protected student speech. But what expression is protected and what expression is not protected? It's easiest to think of it this way. Speech being protected is the rule, and speech being unprotected are the exceptions. So speech is always protected unless it falls into one of the few narrowly defined exceptions to the First Amendment. Those exceptions include things like true threats, defamation, incitement to violence, obscenity, or harassment. But each of those categories of unprotected speech is very, very narrowly defined, and the names can be really misleading. For example, obscenity might sound like it refers to any pornographic or foul language, but it actually is much narrower than that. As law professor Kathleen Sullivan puts it, obscenity actually refers to speech that both, quote, turns you on and grosses you out, end quote, in a patently offensive way. All of this means that even on a public college campus, things like political expression, religious expression, porn, parody, swearing, and vulgarity are absolutely protected expression. Public college administrators cannot prohibit and punish students for these types of speech, even when they might be very offensive or frustrating for the campus community. But what about on a private college campus? The First Amendment and the Constitution generally only apply to actions taken by government officials and not by private entities like private colleges and their administrators. But private colleges and universities are not completely off the hook. Many private colleges, including both secular and religious institutions, have policies committing to uphold freedom of expression on their campuses. In these cases, some courts have found that those policies become a binding contract between a college and its students, meaning that abridging free expression when a college has a policy promising to uphold it could actually be a breach of contract. In other words, once a private college or university promises its students the right to free speech, it has to uphold that promise. And the First Amendment serves as a really useful barometer for administrators at these private colleges when they're trying to decide what speech they can and what speech they can't prohibit while abiding by their free speech promises. So if the First Amendment protects students' right to free expression at public colleges and serves as a good measure for the right to free speech at private colleges, what exactly does this mean for college culture? Well, it means that you have the freedom to explore ideas that you may have never even considered before leaving your hometown. It means that you have the freedom to speak up when you disagree with your student government or your professors or even your administrators. It means colleges can't just silence marginalized voices because they might be inconvenient. It means that you have the opportunity to engage with and learn from a great diversity of people from different walks of life and different schools of thought.